The petition.
Yeah, at the moment, I don't know what will come out over here, but it's possible. So therefore, what am I being punctured or what am I being hit by? As your lordship correct.
Persons who at that particular period gone out and probably they have taken some Indian currency out and they are bringing it to those persons who had gone out but kept the money in India. Which notification applies?
Nothing. Surely you should exercise your power. It's coupled with the duty to exercise your power to cover me under the notification. So that's the softer approach in terms of we don't need to strike down anything, but it's something which they have a duty and a responsibility. They have the power for sure under 4. They must exercise that power. So this is broadly, your lordships are correct. This is exactly where I am. Either under section 4 you cover me, I mean, then I'm happy. If not, if they're still refusing to, because nothing, they've said on affidavit, no, we're not going to do it, come whatever. And we are not obliged to do it, despite all these representations which are made. I'm seeking the intervention of the court. And if that indicate. It'll come in my list of dates. I made a representation to the Reserve Bank of India. The Reserve Bank of India rejected the representation. Then after representations were made, etc., they said also that the matter is sub judice, etc. So now for whatever reason.
No, is it for the reason that it is contrary to the proviso at page?
Yes, that's how I read it.
Page
They said that we are not qualified.
No, what is the reason given by them for rejecting your request?
And also, no, because he came.
It's an oral rejection. It will come in my list of dates.
No, because in an individual case like yours, if the Reserve Bank, though your case is genuine, does not consider a case,
Yeah.
and the board also refuses representation,
Yeah.
individual directions could be issued under Article 226 or even under 32 by the
Of course, it must be.
without going to the other question.
Yes, I believe so. I do. That's exactly my point. My point is that under section, that's that power coupled with duty. You have a duty to exercise this. Read it, Manoj, I will. So I'm just formulating it from my perspective. I'm in 100% agreement with the formulation from the court or the tentative observation from the court. where the spouse had kept the money, it was too late. And she's also been excluded from this. So you will, your Lordship may reflect on this on individual cases, but another way of looking at it is, given the vastness of our country and the circumstances, you may have to have a more broader approach on the part of RBI, not on the part of the court. On the part of RBI, you have to have a general circular for circumstances like this. You can't have a hard stop over here, 30th December, we have an ordinance, 31st December, goodbye to everybody. So anyway, that's the background. Now, just to complete this compilation, you may just note, you needn't turn to the pages. Page 62 is my writ petition in this court. The prayer at that point of time was to strike down these onerous conditions in the RBI circular, which is at page 71. Then, of course, 71. Then, of course, your Lordship knows that mine was disposed of. I was allowed to make an intervention. Intervention application, which basically is only to set out facts, is also mentioned over here. Now, just have a look, your Lordship. We just go same compilation, page 84. So, I'm sorry. May I just complete that? One or two dates are left in the list of dates. Page 7, please. Applicant returned to India on 3rd February 2017. Page 7 of my list of dates. Applicant returned to India. 8th February 17, the applicant approached Reserve Bank of India, New Delhi office, with the demonetized bank notes, a total of 1,62,000 along with the required documents. RBI refused to accept the old notes. The applicant addressed a letter to RBI requesting it to accept the old notes of amount of 1,62,000 in his possession, which were held in savings for the purpose of the knee operation. Notably, the letter bears an acknowledgement by the RBI. RBI orally, that's the officer, informed the applicant that only those persons who are out of India from 10th of December to 30th December 16 and have declared their currency to the customs authorities at the airport can deposit the same with the RBI. In the applicant's case, he was not carrying the old notes upon arrival. As the notes were lying in his house in his absence. The applicant's case was thus not covered by the circular. Then the 27th February is the act which comes into force, replacing the ordinance. Please go overleaf, page 8. 3rd March 2017, agreed by the refusal of RBI to accept the specified notes, the applicant filed writ petition. Then on 6th March 2017 is the order of this court, which I have already placed before this court. 21st March 2017, the court issued notice on the applicant's writ petition. We have set out the prayer. Then on 7th April 2017, the central government filed a short affidavit in one of the tag matters stating that there is no legal duty on the part of government to extend the grace period and declined to exercise the power conferred under section 412 of the ordinance. On 30th August 2017, Press Information Bureau published a note. This, your Lordship will find, is at page 64 and 65 of the compilation. From the reports, data published by RBI, currency in rupees 1,000 and 5,000 denomination in circulation was at rupees 15.44 lakh crore. Now see the next part. Taking into consideration the value of SBNs now reported to have been counted, approximately 98.96% of the SBNs in value terms have come back to RBI after demonetization. In other words, only an estimated 16,000 crores worth of SBNs have not come back to the RBI so far. Now see the importance of this point. By 30th August 2017, they had already received back 98.96% of the notes. So why have this hostile discrimination against people like me, who genuinely had gone abroad, genuine money, and you are just in this area of 0.04%, 0.04% genuine people, and you are saying, no, we won't accept your notes. Sorry, it should be 1.04, 1.98 it is, 1.04. Then 3rd November 2017, this order also I have already mentioned to the court. Top of page 10, we've given you that news report also. During the hearing, the learned Attorney General only submitted that no action will be taken against the petitioners who are before the court for the amount of specified notes held by them and disclosed in their respective petitions. The Attorney General's submission is noted in the news report at pages 84 to 87 of the compilation. Writ petition was declared to be infructuous. That is the cooperative banks, etc. And we've got a news report with regard to that. Then we filed an IA, and then it comes to be tagged, etc. Notice for interventions, etc. Now, just returning back to compilation. So, Manoj, now I'm done with the list of dates. Sorry.
In a genuine case, but if a case is not genuine, what happens? For example, incidentally, you may have gone abroad and you came, and some people will take advantage of this situation, may park their black money with you, and
But
There's a limit on
I'm not in a case.
There's a limit.
That's a concern your lordship will be alive to. But that doesn't mean. I just answer in a moment.
Section 2, the Reserve Bank may, if satisfied, maybe they must hold an inquiry perhaps. Subsection 2 of section.
The lordships have also, now we have the advantage of a 9-judge bench and a 5-judge bench, a constitution bench judgment in Puttaswamy, which says there is a presumption of integrity on the part of the average citizen. Everybody is not some money launderer. That's the logic which this court has used. You can't think and label everyone as a money launderer, and therefore we are going to completely disable all your bank accounts unless you get it linked to Aadhaar or whatever. It's struck down by this court. So there's a presumption that people are genuine, are honest. In my case, there's no doubt in my mind that I am genuine and honest. I've given you the circumstances. Nobody says otherwise. So where is the question of my property being deprived of my hard-earned money and my property?
But under the proviso, I think there is a cap. .96 amount has returned.
Has come back.
So there can be no real, apprehension about a lot of money being parked.
Absolutely.
It's only 1.04%.
The foundation. To that question. So I am first of all in agreement with that. Yeah.
Attorney,
Logically.
what do you think? Because, prima facie, we find that subsection 2 of subsection 4.1, subsection 2 is independent of 4.1. And the notification which is issued is under only subsection 1 of section 4.
Both.
The duty cast upon the RBI to consider genuine cases independent.
That's right.
And that is independent of 4.1 and independent of the notification.
Let me put it even outside all these
So
provisions.
therefore, some such genuine cases are concerned.
That's right. I close my eyes to all these provisions and say there's an element of fairness. There is something which is missing in the whole scheme of the act. For the RBA, that's why subsection 2 talks about the RBA to consider. So I'm trying to look into it and I'll come back and say whatever need to be said. I'm trying to collect the entire
But if
picture.
such genuine grievances are resolved by taking recourse to subsection 2 and subsection 3, there might be a hard case where a person must be in a commanding situation
That
for
whatever
6 months.
you're also saying something. Whatever examination the RBA will undertake in a given case will certainly should be on a fair basis.
It is on a factual basis.
Correct. And also take into consideration whether it will have the tainted aspect of it.
No, they
So how
can
do they consider
The
that?
language itself
source
says,
of funds.
making such verification as it may consider.
That takes into it. That's right.
It's broad enough.
That's right.
Cover it
Anyway, on some individual case, I'm trying to look
And
into it.
Mr. Attorney, 98% you have already come back, some small thing.
Small
I
people
have
are-
collected some information.
So
I'm
you-
trying
you-
to find out how to
No,
put
no.
it in a proper framework, and I'm sure that will be.
So I don't suppose if some person
Your Lordship, please.
is in a comatic situation for 6 months. And this period comes during that period. His children don't know where his money is. He might have kept in a locker or and if you get
Any number of circumstances.
if
I
you
know.
are satisfied that it was beyond his control to apply within particular period. So in such cases, you must provide for some remedy. And prima facie subsection 2 and subsection 3 takes care of that situation.
That's true.
It,
That's the intent.
yeah,
That's the intent.
it bestows a discretion upon the RBI and also a duty that to find out whether the reasons given are genuine or not.
Yes.
That's why I said I'm trying to examine some of the
Yes, yes.
cases. I'll try.
So then, at least Mr. Shyam
In fact, I thought
and the learned friend, he's fighting for 30,000 from last so many days. So their grievance would be taken care of.
Attorney, actually, that 30,000 we thought we'll ourselves take care. Then we thought Shyam Diwan will ask for his share. It was beyond our salary.
it's not 1,62,000.
Oh,
So maybe, so therefore, if we can just think loudly about this, at least these independent cases could be taken care of.
Yes.
Let me come back.
You could always verify about the source of funds.
Yeah, as I said, I collected some information. But I want to look at it a little more closely so that if there are some doubtful cases, can we weed them out and see how it comes.
So if he is not in a position to satisfy that his claim is genuine,
Yes.
can be outrightly rejected. If it can be found out from the account that it was withdrawn immediately before he left India.
What I was trying to look at some of the instances, the bona fides of people who have tendered, the way they have tendered, things like that, all that will be taken into account. Therefore, I think I need a little closer attention to that have to come back.
Thank you.
No, well, sorry.
We are saying something in your favor, Mr.
My lord, it is only 2 pages and
Let Mr. Diwan complete.
two, my lord, 77219 of 2017, my lord.
We'll hear you fully.
He has not yet completed.
Yes.
In a lighter vein, I think you have been like Lord Ganesha. So every morning we come, first see you and then go to the, going out we see you and then go out.
He blesses the court.
And he's also sitting in the middle.
But in every temple, first you will have to go to the Ganesha and then go to the others.
No, Manoj, of the RBI Act 1934 cease to be legal tender in payment of or on account at any place. Section 4, which prohibits transfer and receipt of high denomination banknotes, reads as follows. And then Section 4 is set out. Please go to the discussion at paragraph 6, page 107. In assailing the Demonetization Act, it was contended on behalf of the petitioners that it violated the fundamental rights guaranteed under 19(1)(f) and 31 of the Constitution since repealed, which were available to them at the material time. In elaborating upon this contention, it was submitted that Section 26 of the RBI Act casts an obligation on the bank to make payment of high denomination banknotes wherever tendered, and the central government guaranteed such payment. But on promulgation of the impugned act, those notes cease to be legal tender, notwithstanding the above provision of the RBI Act in view of Section 3 thereof, and resultantly, the bank and for that matter, the central government stood discharged of their obligations. In other words, according to the petitioners, the impugned act extinguished the debts due owing from the bank to the holders of high denomination banknotes. The petitioners contended that such extinguishment of debts amounted to a compulsory acquisition of property within the meaning of Article 31(2) of the Constitution, and since the acquisition was not made for a public purpose, nor adequate and appropriate provisions were incorporated in the impugned act for payment of compensation in respect of the impugned act was violative of the above article. Besides, the petitioners contend that they had a right to acquire and hold the high denomination banknotes and to carry on any trade or business by using the same in the course and thereof, and Demonetization Act, insofar as it provided for non-payment of exchange value of high denomination banknotes, except in the cases under Section 7 and 8 thereof, it imposes an unreasonable restriction on the fundamental right under 19(1)(f) and (g) of the Constitution. Since it cannot be disputed that the direct effect of the 1978 ordinance is wiping out of a public debt owing to the holder of high denomination banknotes from the state, the other contention of the petitioners that their property was compulsorily acquired has got to be accepted in view of the Constitution Bench judgment in Madan Mohan Pathak, wherein it has been held that property within the meaning of Article 19(1)(f) and Clause 2 of Article 31 comprises every form of property, tangible or intangible, including debts and choses in action, and the extinguishment of a public debt due and owing to the state amounts to compulsory acquisition of such debt. The next question necessarily falls for consideration is whether there is a public purpose, etc. And then they get into the point, then they finally find that there is a public purpose, and then your lordship will just note from para 11 onwards, or after para 11, the writ petitions are, there are two writ petitions which are individually taken up and considered by the court. I'm just explaining the scheme. The individual facts, etc. are not relevant. So this is really for the purpose of completeness to inform your lordships that there is a Constitution Bench judgment. Sorry.
You found
you may just see paragraph 11 at page 109, and then I'm done with this volume. Part of this Constitution bench judgment. Now that we have found that the Demonetization Act to be a valid piece of legislation, we may proceed to consider whether the orders passed by the respondent in exercise of powers thereunder, refusing to exchange the high denomination banknotes of the respective petitioners of the writ petitions, are justified.
So this paragraph 11 is binding on us.
It is. So the Demonetization Act, that act was found to be valid, no problem. And thereafter they went into individual grievances. That's the broad scheme over there. It's your lordship will consider, will apply this case also in terms. I don't think anybody is saying that there's no public purpose as in the sense that that's not my case.
This is binding
But,
on us.
yes. Now please have a look at the second volume, volume 2, which was titled that compilation, yes, documents on behalf of the applicant. There's just 2 or 3 things I want to point here and then I'm done. Now, I'll just state the point. One of the points which was mentioned yesterday by Mr. Chidambaram was that there is perhaps a necessity for your lordships to lay down under 26(2) and other parts of the RBI Act certain guardrails. And the guardrails are necessary to know as to what are the elements or what is the extent of discretion available, how is that particular power to be exercised, etc. Now, in that context, I just want your lordships to recognize 2 or 3 pages over here. So please go to page 32. Page 32 at 56. I'm just going to read one statistic here. The page numbers are at the foot, I think. So this is using fast frequency household survey data to estimate the impact of demonetization on employment. And please just go to the conclusion at page 56, which is print page 183 of the article. The employment and unemployment estimates created from earlier indicate that the labor participation rate fell by about 3% after demonetization. Employment during the busy October to December 2016 quarter was 0.5 million lower than the preceding quarter of July to September 2016. And the expected spike in employment during the quarter was missing. Employment during the 2 months following demonetization was about 12 million lower. So this is 1.2 crores lower than it was during the 2 months preceding demonetization. And after a 4-month period, when the entire sample is surveyed, the impact of demonetization reduces to a loss of about 3 million jobs, which is 30 lakh jobs. So you see, decisions, of course, there is government policy, etc. They are fully entitled to make policy decisions. Many policy decisions are good, beneficial. Many sometimes it's an element of experimentation. It may work partially, it may not. I'm not faulting anybody on that. The point which was made yesterday and which I'll emphasize in my turn when I come to 26(2) is it's very important for this court to lay down the parameters and the guardrails. That is necessary because look at the impact, Manoj. We're talking about 1.2 crore jobs which are lost in the near term. It was transient. The impact was transient. And then it went down to 30 lakhs after job loss. But 30 lakh job loss, we're talking about life and livelihood. If there are sufficient parameters, of course, then it may not be necessary. But if you feel that there's a necessity to lay down appropriate parameters for the exercise under 26(2), then please consider it because the impact is extraordinary. And the impact runs, it really impacts families, etc. in a very, very, in a manner which is palpable. Now, please go straight away to page, so your lordship may just see the very next page, page 57 and 58. Same, in the same vein, this is a news report of January 17, 2017. So the first statistic is on employment. The other is this report and study carried out by the All India Manufacturers Association. And please see the third paragraph. AIMO said that that those in the age group 40 to 45 are the worst hit, and 40% job losses due to the note ban based on data till December 31st. It also records that 32% of the people in the age group 22 to 30 have lost their jobs. The report says that till December 31st, some 60% job loss were reported in the sector, along with 47% dip in revenue on part of the small-scale traders, shops and micro-industries, medium-scale industries, etc. So we are not, this is not a critique of the policy at all, not at all. This is only to come back to the court and indicate that the exercise of such powers, if left untrammeled and without any guidance from the court can have huge human impacts which affect life and livelihood. So I am done with this. The only other page here which I want to point out, you have already seen. Sorry.
Yamdivan, what guidelines you have suggested?
Yes, so I am going to
Have you
suggest.
suggested any guidelines?
Yes, so
Put it in a sheet of paper and.
yes, so I'll
What
just,
guidelines?
just answer it in one line first, in addition to what Mr. Chidambaram has covered the ground. And my respectful submission is going to be when you see the reports and hear them, at a minimum, when you are taking away 86.4% of the currency in terms of value, at a minimum, and this is based on your lordship's jurisprudence, there has to be a study. There can't be some general study on black money, trafficking, counterfeiting, fake notes, that there are dozens of studies. They have given some 7 volumes of study after study. There's not one study on the benefit or not the benefit of demonetization as a solution to all these problems. Some study when you are going for 86.4%. I mean, how does anyone apply his mind, his or her mind? Some base. So I am not on the point.
Made in public domain.
There are 2 elements here. On disclosure, that's an important principle which Mr. Chidambaram has projected. Disclosure of the minutes, the notice, the advice, the agenda notes, etc. That's one element. And then whatever inference, they seem a little coy at this point at least from revealing it to the court, but I'm not on that. It's not even their case that there was some type of meaningful study on what the impacts will be and what the benefits could be in terms of these particular benefits. So some general study that, oh, there's a lot of problems because of black money and there's a huge problem of terrorism and trafficking and etc. is neither here nor there. There has to be, that's our understanding. In the context, because the question is, are there any guidelines which we are suggesting on 26.2? My specific answer is, there has to be some, it may be confidential, it may be meaningful, it may be 6 months earlier. I'm not saying it has to be contemporary. There's an element obviously of secrecy, etc., which has to come for a policy decision of this sort. But surely there has to, ought to be, I can't say has to be, ought to be a study is the short answer which I'm giving your lordships in terms of the guidelines. I'll deal with that very briefly. Now only 2 pages are left.
One thing,
Yeah.
if a specific study with regard to demonetization was undertaken, say 6 months earlier or 1 year earlier, and it would have come in public domain, then what would have been the result?
No, I think, let me put it this way. There has to, I think the question is a very important one. Question is, are there, how is you see, the language uses recommendation, your lordship requires that, 2060. Now, when we are talking about, according to us, it has to be an informed recommendation. I mean, that's the basis. I mean, we are talking about Central Board of the Reserve Bank of India. I mean, if these people don't apply their mind, it will be at considerable peril to all of us. So there is a presumption that this is the highest degree of scrutiny and application of mind, which is going on. Application of mind to what? That's the question which your lordship is correctly putting to me. There may, and I concede and I accept, that there could be possibilities that if some long-wide study with some great this thing takes place, there may be some element of secrecy which is lost. That's a valid consideration which you'll have to keep in mind. But was there any study which had recommended demonetization on this scale, which would address those particular objects which they seek to achieve? At least that is the minimum. And was that placed before before the board which took a decision? So study one, but I appreciate the perils of what the court has pointed out. That look, where there's an element of secrecy, what sort of study? I mean, are we going to go to every? No, I'm not suggesting that at all. So was there anything at all? I think some minimal study on impacts would be there. Because I don't think the central government the central government at the highest may have some.
We'll have to only take into consideration as to whether both the RBI as well as the government.
Yeah.
Why the RBI while recommending and the government while taking a decision.
Yeah. That's some material.
Have taken into consideration relevant factors and relevant material or not. Or as to whether they have taken into consideration the irrelevant factors and irrelevant.
No, Manoj, I think your lordship has put it very succinctly. I agree with that. The question is whether relevant material, when these impacts are there, now your lordship knows the impacts over here.
In this context,
Yeah.
did the RBI informed the central government that 86.64% of the currency would be withdrawn from the people of India? Was this fact informed to the central government or not?
So they are quite
Because
coy.
this is the enormity of the entire exercise.
No, they are
and the-
quite coy,
No,
and
no.
maybe with justification.
You have now argued it is for them to satisfy.
Yeah, correct. I am sure they may. But now I've got only 2 pages left. So that one page, which is page 64. So, Milord, to answer the question, which Justice Nagaratna put.
No, if this was informed, then the question is whether central government would have done this or not.
Yeah, so your lordship is right to put it to them. I have not found anything on the record, but I'll. Now, whether even it was available before the board is not known. This report which I read to your lordship is a subsequent currency report. So this page 64 of this compilation, volume 2, and now I'm done with this compilation, has that figure. It's the Press Information Bureau release where we get that
Rate closed by Mr. Chidambaram.
98.96%, correct? And the last thing which you in that compilation, page 66, just see what they did. Because ultimately when we argue section 4, it's going to be something like this. Government allows cooperative banks to deposit old notes with the Reserve Bank of India. The relaxation comes in the backdrop of reports that many district cooperative banks did not have enough cash to disburse to farmers, etc. And therefore they took appropriate and suitable action in terms of these under 412. So, I mean, they exercised the power. It's not that they did. So, Milord, now I'm done with this. So now may I just come to my submissions? So the first submission I want to make is on Article 300, capital A. Let me just state the points and then I'll take you to one decision of KT Plantation. So number 1, there can be no deprivation of property except saved by authority of law. Number 2, this has, sorry.
Justice Mukherjee's judgment in that constitution bench, all these points are covered there.
Correct, I agree.
I think we need not go into other judgments.
All right,
It's
you
a
need
constitution judgment.
Yes. So there are 3 things which I just want to mention. Well, first of all, it is quite, I think by now, it's an old judgment I'm citing. So we need not possibly have to actually read the paragraphs, but I'll still mention the paragraphs to you. And I'll mention the points to you on 300A. So, Milord, at least I didn't find that your lordship sitting as a panel in a constitution bench have so far held that property is a human right. So we have at least 4 decisions of this court in smaller combinations which recognize that
What has been held in the earlier case with regard to 31, Article 31?
Yeah.
With regard to property,
Right.
it only applicable to 300A.
Yes.
I agree with you. I agree with you.
We'll have to hold that is also a property.
Yes.
No,
And,
none of us have a dispute
Yes.
Right.
that it's a property right in the 300A.
Right.
Unnecessarily, labor on a point where
Okay, so no laboring on the point. So let's just summarize it then.
Unless we disagree with that,
Right.
we are bound by the 5 judges bench.
Correct. So I'll do only 2 things. So first, your lordships have seen my dilemma, which is that my property has been extinguished. You have already fought. That's my whole complaint. That's why I'm here before the court. Rendered note.
Or all of us, we prima facie find that such hard cases have to be dealt with in an appropriate manner.
I'm grateful. So that is point number 1. It can't be extinguished or rendered not. And the second is that the law itself must pass constitutional muster. So it's not enough authority of law has to be. So that's well said. So may I just give you paragraphs? Would you like paragraphs? Should I put it in a note? Then you need not note it. So KT Plantation is the constitution bench by Judge Panel.
Don't make it too lengthy.
No, I won't. I'll just give you the paras. I won't quote the paras. So that now my 300A point is over. So that's over. 300A. So now we come to the second point. The second point is on Article 14. Now, Article 14, there are many dimensions. So I will.
Argument is based upon the proviso to the notification. Proviso to the notification is issued under 4.1i. Now, if your case is covered by 4.2 and 4.3, notification does not apply. Therefore, Article 14 is not necessary.
No, 14 is necessary for another reason. I'll just tell you. So 14 is, arises in several, there's many dimensions to 14. And it of course, it attacks the very point which your Lordship has correctly put to me. And I have noted your prima facie view under 4.2, etc. So that I recognize. But there are a few other dimensions also, which I'll just project and then your Lordship will consider. So the first point is, I'm going on the classical equality test. And the classical equality test, as we understand it, is that if you are using classification, then everyone who's similarly placed ought to be in that class. So if there's a single homogeneous class, you can't split that class in an artificial manner so as to result in discriminatory treatment.
Many classification.
Yes, you can't. Exactly. Sometimes your Lordships have called it mini classification. Now, which is the homogeneous class which I am talking about? I am talking about people who are outside of India during this period. I'm talking about citizens who are outside of India during this particular period of whatever, 8th of November till 30th of December. We are all part of one class. Now, how can it be that someone who lands 1 week or 2 weeks earlier and is able to exchange his money, gets his money? I come in the month of February and I have no recourse at all. Please just consider, my lord, it's a classic Article 14 situation over here. There's a complete...
While notification would be in the nature of a subordinate legislation.
Notification.
Would be in the nature of a subordinate legislation. While that is issued, all sort of eventualities may not have been taken into consideration. You have created two classes. One is
that's what I'm saying.
One is with regard to resident.
Right.
Presume that a resident normally goes for some time and comes back to India, and for them there is no limit.
Right.
No outer limit, no requirement of any certification. They could have gone up to 30th of March and without any requirement could have exchanged it. Insofar as NRIs are concerned, the requirement, NRIs normally, as we understand, are those persons who normally reside out of India.
Yes, so 180 days.
And
we'll just check up.
180. Normally in common parlance,
180.
they are citizen of India, but for all purposes they are resident abroad. And for them, such a restriction is imposed. So, if we read that subsection 2 and subsection 2 and 3 empower RBI to take a call on such a situation, and there is a power coupled with duty to consider such cases.
To that,
then whether Article 14 would be applicable.
No, see, we on this side.
That question may not arise at all.
No, so I am not saying no to that at all. I am, see, the reason I'm projecting, first of all, I'm agreeing with the court. I'm agreeing with the court that if I get relief on...
The classification between an NRI and a resident Indian is a reasonable classification.
That depends for what purpose. See, that purpose is because of the grace period definition here, correct? 31st March or June. That's the scheme over here. So I am not quarreling with that. Let me just restate it. Maybe I didn't make myself.
Yours is one of those very few cases which would fall in the category of hard cases.
No,
had you not been out of India for a particular number of days, then you would have been a resident Indian.
So I am looking at it differently. Sorry.
And entitled to treat it in clause A.
No, so I accept that. My point is a little different. Yes, the approach is different. First of all, Malad, I want to accept that if I receive substantial relief, I mean real relief in terms of section, whatever, an appropriate direction because of power coupled with duty, then this issue which I am raising may in a sense not arise in terms of determination by the court. But it's important to recognize the issue because it elevates the degree of the duty, the bounden duty of RBI or the case of or the central government as the case may be. Now, what's that point? The point I am making is there's an artificial line which is being drawn on the 30th/31st of December 2016. There are people who arrived before. Just look at the situation. There are people who came back into the country before on 20th of December 2016. They had booked their, nowadays your lordship knows the only way to get an affordable ticket is to book it well in advance. So some people have plans to book it in advance. Some people have plans to have booked the ticket at the time of their leaving well in advance. It's a reasonably fair ticket. I was to come back in the month of February 2017. Now, the question I asked myself is, the first point I'm raising just on this homogeneous class is that look, how am I any different from a person who came back to India, say on the 20th of December and therefore had time, and me who relied upon or who was aware of the Prime Minister's declaration to the country, the Reserve Bank of India statement to the country, which said that people, don't worry, when you come back, you will have an option of going to the Reserve Bank of India. I am in the same class. Now, this is my point. I want to say nothing further. I am in the same class to artificially exclude me from a class of Indians who didn't arrive, even though held valid currency in India, is according to me an arbitrary classification. So this is my first point.
According to you, there is no nexus with the classification.
Now that's the second point. The second point is that the nexus is, or ought to be, that's what they've said repeatedly, black money. Second is fake notes, that means counterfeit or whatever fake in some other manner.
Drug trafficking.
Drug trafficking. And yes, so these are essentially the trafficking, fake currency, etc. and terrorism. Your lordship recalls that also, terrorism. Now, what is the connection with my hard-earned money and any of these objects which they are seeking to achieve? So that's the second infirmity under the classical test under Article 40. There's no rational nexus. I'm sorry.
When rules are general rules applicable to lakhs and crores of people are being made, can individual cases be?
They must be.
Consideration.
No, they must be. In my respectful submission, see, Milord, this is the other way of looking at it is there the rational nexus which you have, terrorism, etc., you have to have a caliber. I'm moving into my next point actually on proportionality. That's also an aspect of Section 4, etc. You have to have a proportionate set of regulations. You can't deprive some people of their money when they have nothing to do with terrorism and they've got nothing at all to do with any of this counterfeiting, etc. And I have these genuine notes and you can see my notes. And it's 1,62,000 of hard-earned money which I had taken out, which I had kept at home. It's not an uncommon circumstance at all, my lords. And therefore, there's no nexus to the object which you're seeking to achieve. And you can't have a situation that because this is in some larger public interest, my fundamental right or my constitutional right will suffer. You have to have a calibrated response either through appropriate notifications or through appropriate rules and regulations or through an appropriate scheme by which a person like me cannot be disadvantaged. Anyway, that's my submission. That's my submission with regard to this. Then there's an element of manifest arbitrariness. Now, why am I using this expression manifest arbitrariness? We are emboldened because no less than the Prime Minister of India gave an assurance to the people of India. Now, once the Prime Minister of India says you will have RBI counters to go to, and the Reserve Bank of India and the press releases which are contemporaneous echo the same sentiment, then the question I ask myself, isn't it manifestly arbitrary to introduce an ordinance on the 30th of December which has a guillotine on the 31st of December? 1 day given. How can anyone change his or her affairs? So therefore, the measure and the baseline for what is reasonable ought to be, we have the advantage of a solemn assurance and a statement made by the Prime Minister, no less. In a situation like that, that is surely the yardstick of reasonableness. If that is the yardstick of reasonableness of whatever people expect, etc., you can't suddenly introduce an ordinance on the 30th of December and saying that I'm giving you no effective window to change your money at all. And there's a hard stop which comes in on the 31st of December, and that is that. So this is my other element with regard to manifest arbitrariness, founded on the representations which were made to the country at large. And finally, I've already mentioned the doctrine of proportionality. Mr. Chidambaram has explained that at length in the context.
Relied on my learned brother's judgment.
Yes, so that's a useful. So, my lords, I will state now. Let me just state there are at least 3 decisions of our court which I'm just indicating, and I'll tell you what they say as well, and then we'll, if necessary, go into the paragraphs. So now, as far as proportionality is concerned, it arose in the Puttaswamy 5-judge bench judgment. I'm not going to the judgment. I'm just explaining it because I'm going to give you a note with the relevant paragraphs. One of the requirements was one of the challenges in Puttaswamy before the 5 learned judges was the mandatory linking of Aadhaar to bank accounts. And this was brought about by an amendment to the rules which deal with money laundering. So the argument on behalf of the state, the union government was that, look, this is money laundering, this is anti-terrorism, this is this, this is that, and therefore this is a matter of financial policy, etc. Please allow and sustain this linking. What this court said is that you cannot have, that's the expression which your lordships have also used.
Yesterday, Mr. Chidambaram had read those paragraphs.
Yes, those paragraphs. So we have now 2. So he read to a couple of those paragraphs, which clearly indicate that just having a ritualistic incantation, that is the paragraph which they read, is not sufficient. And if this is hard-earned money of individuals, so what was the principle? The principle applies over here. You have crores of people with bank accounts across the country. You can't disable valid earned money value in those bank accounts by saying that if this is not linked, then as far as that particular money which is lying there, there'll be a presumption that this is whatever proceeds of crime or money laundering or will fall foul. It will fall foul of the money laundering rules. And this court struck it down and said, using the doctrine of proportionality, that there has to be something which is more calibrated and reasonable. So this is my final dimension. As far as Article 14 and proportionality is concerned, there ought to be something which allows a route out for persons such as me is concerned. Now, I want another, I'll just mention another item and then I'll put it in the note. I think there's a very important aspect of dignity in this case. The very important aspect of dignity. Dignity has now been recognized by the 9-judge bench in Puttaswamy as being basic element as far as constitutional values are concerned and the right to life. Now I'm on 21 and dignity. I would respectfully submit that traveling to the United States to visit a son and a family member, son, daughter, whatever, is part of our overall understanding of dignity, of having family, of emotional bonds, of renewing those bonds, of enjoying the company, of looking after whatever grandchildren if there are, and being looked after. All of this is a very important facet of dignity. And you cannot or you ought not have a situation where suddenly the Prime Minister makes an announcement, I have to immediately pack my bags and rush down. Forget that issue which I mentioned about the statement and the assurance made to the people of India. No, dignity is something which I carry along with me. Your Lordship have used that expression also. I mean, in the context of privacy, being a portable right. It's a traveling right. The dignity comes with me. You have your Lordships in Maneka Gandhi, etc. The right to travel abroad has been recognized. So the right to travel abroad, the right to travel and reside with my family, the right to stay abroad, all of that cannot be diminished by saying that, all right, go and travel abroad, stay abroad, but your 1,62,000 or whatever amount which is remaining over here vanishes. So this impacts established rights in terms of dignity, the right to travel abroad, and an important dimension of property, not 300 days so much. But the security of property is also something which is an element of 21. When I traveled abroad, I knew that this 1,61,200 was secure in my home, whatever, under lock, cupboard, etc. And all of a sudden,
in a lighter vein,
yeah,
if a person goes out of country
yeah,
for a considerable time,
yeah,
rather than withdrawing the amount from the bank, he would deposit the amount in cash to keep it safe.
yeah. So here,
lighter vein.
right. No, so here you will see my deal. But anyway, I have a withdrawal slip, etc.
You have a withdrawal slip, so
Yeah. Right.
rather than
I inquired actually.
having a threat of theft, and if one is traveling for 9 months,
Right.
ordinary course you will say whatever cash I have, I will put it in the bank so that it is safe.
Or locker.
Or locker.
That may be. So what had happened here, I inquired. Fortunately, he didn't have to go through that knee surgery. He had collected certain money, etc., for a knee surgery, but then the treatment outside the surgical thing worked for him, though he had to undergo certain other surgery. We were not on that. So that was the original rationale for having withdrawn the amount and kept it in safe custody. So this is my point.
But at
Now,
any
sorry.
rate, they relaxed the whole thing insofar as cooperative banks are concerned.
Yeah, absolutely.
See, that was done in June, 6 months later or
Yes.
6
Yes.
months later, they have relaxed
Correct.
for cooperative banks.
Right.
So that all the money which they had stocked, they could exchange.
Absolutely. Exactly what I wanted to say.
If you put it to the learned attorney, I think he will
Respond to that.
respond to that.
Yes.
All right. Now I have 2 points. Sorry. Yes. So, Manoj, I have 2 points to make. For one is on that your lordships have already grasped it. I don't know whether you require me to make any further submission. I suppose the answer is obviously no. Any further comments with regard to that section 4? I think power coupled with duty, your lordships are completely alive to that.
Yes.
There are, I mean, it's a well established.
You can give in your written note whatever. If you are relying on something.
Now, then I will, your lordship will just give me a moment. I mean, there's a minute left or less. Now, the final point which I wanted to make, may I just continue? I'll just wrap it up immediately after.
How long will it take? 5 minutes?
Maybe 5 to 10 minutes. I'll just, because there was a moment.
5 minutes.
We will, I think,
Complete.
rather than finish it right now.
All right, fair enough. No, no, they can wait there, Manoj. I'll be less than 5 minutes.
They
You
will be
you
hearing the
disturbed by
arguments.
them.
Oh.
You will disturbed by them.
So now I want to just step back. Sorry. Aspect of section 26(2). That's all. I'll take a minute or two on that. Now, Mr. Chidambaram has made exhaustive submissions on that. So point I made a short while ago on this 86% of the entire currency. First, the expression is recommendation. 26(2). I'm only on 26(2). Now, if it's a recommendation at this level, did they, at least the basic elements, I believe, ought to be told to this court, and one of them has been correctly pointed out, which is the quantum, 86%. Did the central board even know about this? That's one. Second element I suggested in terms of guardrails is some study, contemporary, specific to demonetization. I'm not going.
That you already addressed.
I have mentioned it, and some study, some basic study, but not some general study on black money, and those are sort of cheaper by the dozen. Those you'll get any number of on some trafficking and this and that. The point I'm making is demonetization as a solution. The impact after 86%, whether that was known, and the impact, I think that's very important. Otherwise, my only additional point is the expression recommendation takes in or draws into it conceptually and information being received by the party recommending, deliberations at the highest level before making the recommendation, and thereafter some kind of a meaningful application of mind. Now, unfortunately, using that expression ritualistic, they have in a ritualistic manner on those affidavits, which Mr. Chidambaram yesterday pointed out, those 3 or 4 paragraphs, said that there was a communication from the government to them, to the central board, meeting was convened, and the whole thing, and the recommendation arrived, and pursuant to that, a decision and call was taken. I don't believe the requirements of 26(2) are also fulfilled. I'm very grateful. Thank you.
Thank you very much.
Who will start at 2?
We must consider the applications which are now pending. Applications.
No, I think substantially it is argued. Now we will ask the learned attorney to respond.
On the tax models, we are almost similar here also.
All right, you have said no, that we have all, now the attorney has said he will examine. Please listen to us. See, if the attorney said he will examine, that aspect, whether how to safeguard your interest, he will come back.
The only difference is, my lords, in my application is
That
we had
should be a
made
part of your representation if the attorney agrees, no?
We had made representation as per their.
You make one more, we'll allow you, nothing to worry, provided we should, all right.
Well, I will seek your lordship's indulgence to start after 2, because the legal issues which Malad supports half of the submissions made by Mr. Chidambaram on 26-2, but there are many things which needs to be brought to
But
your.
how long will you take? 15 minutes, we will grant you. 15 minutes.
If I satisfy lordship 15, maybe lordship will grant me more indulgence.
No, 15 minutes, and
Lordship,
you can
yes, yes.
support by your
Yes, yes.
written submission
Lordship.
thereafter.
I'm on
15 minutes, 15 minutes.
Lordship, please.
All right. See, everything is covered now. What is there? Anyway, all your names will come in the judgment. Nothing to worry. SEC, it will come.
Slightly different application.
No, all your names will come in SEC. Nothing to worry.
I am seeking specific directions for investigation into the act and conduct of the RBI.
All right, it will take 5 minutes. 5 minutes.
Documents.
Only 5 minutes. 5 minutes. Yes.
I will take 2 minutes.
Huh?
I will take 2 minutes.
That is at the end, no? That's 30,000 rupees issue, no?
Yes, my lord.
All right, we have understood that.
Only 2 minutes I will take.
He repeats any of the submissions and we'll stop them that.
Yes.
Any repetition, we will stop.
Yes, ma'am. Yes, ma'am.
In fact, my lords, on applications, there would be only the difference in the hardships that people would project.
All right,
We are not going into the individual hardships.
we will see, if a provision is made as my brother suggested, and all problems will be solved, including 30,000 issue, right? But you have to spend 60,000 for that.
We will be saved over 30,000.
Then, Mr. Attorney,
Your
you
Lordship.
address at 2:30. Your time, you should start at 2:30.
Very well.
You will be finishing
Very
this side by
Very well.
half an hour.
Very well.
Please start at 2:30.
Right.
No 15 minutes, 2 minutes. We have said this judgment is res judicata now. No. We have already said 2 minutes. Right.
There are some tax societies also which has to be taken care of. So, can you give me just, these are all factual because their amount.
We are giving you 2 minutes, no? You can state that. No, this is res judicata now. It is binding on us.
I will.